America, the state of Tennessee, and this honorable court.
Good morning and welcome to the morning session of the Tennessee Court of Appeals. I want to thank each of you attorneys as well as your parties for agreeing to participate with us in this still sort of new video oral arguments that we're conducting. I want to take just a moment and first of all introduce the panel, and then we'll talk about some very basic procedure here. But your panel for today will be Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah. I'm Steve Stafford from Dyersburg. As all of you know, you're all experienced practitioners with appellate practice. Each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, you may reserve up to 5 minutes of rebuttal time, but you need to request that from the court after you introduce yourself and before you begin your argument. Obviously, appellees get no rebuttal time. It's my understanding that we have two appellees, so what we'll need to do, again, whoever starts the argument will need to know how you're going to split your time, and I'm sure you've already discussed that. I want to thank Mr. Hibner, the clerk of the court. He does a magnificent job putting these things together. I don't think we really understand how much work, how much effort he has to put into that, and we appreciate everything that he does. Also, we want to thank the AOC technology staff. They do wonderful, wonderful work making sure that this thing goes, and we appreciate their efforts. So, Mr. Hibner, if you would call the first case, we shall proceed.
Clarence Hight et al. Versus Donald Ryan Tramel et al.
All right, we will hear from the appellant.
Thank you, Your Honors. My name is David Grimmett, and I represent Mr. Clarence Hight in this matter. I would ask to reserve 5 minutes for rebuttal, please.
All right, sir, you may proceed.
Thank you, Your Honor. This matter primarily involves a question of authority. And in order to review the authority that Mr. Hight has, I believe that we need to look at the facts and the law in this case. Specifically, on February 14th, prior to February 14th, 2012, Mr. Hight controlled and owned a corporation known as Action Security Systems. On February 14th, 2012, the defendant, Mr. Tramel, became a manager at Action Security. On April 11th, 2013, Mr. Tramel entered into a non-compete contract with Action Security, basically saying that he would not steal any clients, he would not steal any employees should he leave Action Security. On February 2nd, 2013, Mr. Tramel left Action Security, and soon thereafter, in March or April of 2013, Mr. Hight learned that he began working for Ace Alarms, a competitor of Action Security. And in February 2014, Mr. Tramel left Ace. This matter involves two separate lawsuits. Excuse me. Specifically, the first lawsuit was filed on April 16th, 2014 by Action Security. And then Mr. Hight sold his shares along with his wife and his daughter of Action Security on September 12th, 2014. Mr. Hight continued to control the litigation during that time. That is an important fact that we would bring to your attention. Specifically, that Mr. Hight is the one who owned the corporation prior to the litigation. Mr. Hight is the one who owned the corporation at the litigation. Mr. Hight is the one who controlled the litigation throughout the litigation. Ultimately, there is no question that Action Security has never said that Mr. Hight does not control this litigation. There is no document, there is no fact that says Action Security denies Mr. Hight's control of this litigation. On January 28th, 2016, Mr. Hight's deposition was taken. And during the course of that deposition, we learned for the first time that Mr. Hight had sold his shares of the corporation. On March 14th of 2016, a settlement agreement was entered between Mr. Hight and Mr. Eric Roberts, who is the sole shareholder of Action. He is the person who bought the shares. Ultimately, in August 2016, the first complaint was non-suited, and then on February 1st, 2017, the second complaint was filed entitled Mr. Hight individually and Mr. Hight on behalf of Action Security. At the trial level, the judge ultimately found, based upon summary judgment, that Mr. Hight did not have authority to file the second lawsuit, and therefore it needs to be dismissed. We would argue that Mr. Hight did have authority. The first primary question is whether Mr. Hight was assigned this litigation based upon the settlement agreement between he and Mr. Roberts. As we have stated in our brief, the primary question is, what is an assignment? And looking at Action Chiropractic, that defines what an assignment is and the elements of an assignment. The elements are specifically that it must contain clear evidence of the intent to transfer. It must describe the subject matter of the assignment. It must be clear and unequivocal. It must be noticed to the obligor, and there also must be an intent the intent to transfer must be manifested. Here, we would argue the language of the assignment is very clear. Specifically, paragraph 6 of the assignment says, the parties hereto agree that the terms of this agreement may be shown to opposing counsel in the lawsuit referenced above in paragraphs 5 through 6 for the sole purpose of showing that Hight has standing in order to pursue that legal action on behalf of Action Security Systems. Now, the question is, what does that language mean? What does it mean to say on behalf of? One of the arguments that has been pressed by the opponents is that the language does not say the word assignment, but the case law in Tennessee says it does not need the word assignment. Specifically, Collier versus Greenbrier says it doesn't need that word at all. You need to look at the actual intent of the parties. And here, the intent was very clear. Here, the intent was to assign all the litigation, all the rights of that litigation to Mr. Hight. Just like Mr. Hight had controlled it up to that point, the parties agreed that he needed to control it even further. One of the arguments that has been pressed by the opponents is that Action Security was not a party to this assignment. Therefore, it's not a proper assignment. But what's interesting is the only people who are arguing that this is not a proper assignment are people who are not a party to that contract. Instead, they are the obligors in this particular case. So ultimately, the question is, what kind of authority did the parties have to assign a right on behalf of Action Security? We would argue that that authority would be under apparent authority. And specifically looking at Mechanics Laundry Service versus Auto Glass, we need to figure out what are the acts of the principal and what are the acts of the agent, and whether the third party, in this case, Mr. Hight, reasonably believed that he was receiving the assignment of the litigation. Here, the acts of the principal, namely Action Security, are very clear. Action Security had this litigation. It continued this litigation. After the settlement was entered, Mr. Hight continued to control the litigation. He was the one that was the party representative. He was the one that made the decisions for the litigation, not Mr. Roberts. The parties intended for Mr. Hight to maintain that litigation. It is clear from the language. Now, ultimately, we also have to look at the four corners of the contract. I believe in the trial court below, the trial court did not pay any attention to paragraph 6. It is clear from the order, the trial court did not rely upon paragraph 6, which is what we are relying upon. Instead, the trial court looked upon other paragraphs where the actual assignment was the proceeds from the litigation. If the proceeds from the litigation were assigned, one would think that they would also have the authority to assign the actual litigation. In this case, that is the argument. Second argument was whether Mr. Hight can go forward with a breach of contract action against Mr. Tramel. We would, of course, argue that if there was a proper assignment, he would be able to do so. Next, the question is whether Mr. Hight is able to utilize the saving statute. I will say this, it might be very much a matter of first impression as to whether you can assign the ability to use a saving statute in litigation. We would argue that an assignment includes everything with the litigation. No ifs, ands, or buts. It must include the ability to utilize, it must include the ability to file the litigation. It must include the ability to refile the litigation using the saving statute. I believe it was Bischoff versus Yarbrough that says that an assignment passes the whole right of the assignor, nothing remaining in him capable of being assigned. And the assignor has no further interest in the subject matter of the assignment. Given that, we would argue that there must be an assignment here, including the voluntary dismissal and the voluntary non-suit. Finally, the question is whether Mr. Hight can go forward on his personal actions against Ace and against Mr. Tramel. One of the questions is what statute should we be relying upon in order to determine the statute of limitations? We would argue that it is 283105A, which is damage to property, specifically because Mr. Hight is arguing the damage was to his shares, the diminished value of his shares. Now, ultimately, the question is, when does the statute begin to run? We would argue that the statute begins to run when Mr. Tramel left Ace Alarms and when the final action occurred. Now, I believe the opposing counsel has argued that this falls under the discovery rule. We would argue that it also falls under something called the continuing claims doctrine, which basically means that we have to look at each individual claim. So ultimately, we have to determine how are we going to determine the statute of limitations. In this case, the defendants were continuing to do separate actions, all part of the same conspiracy to a certain degree. Given that, we would argue that Mr. Hight should be allowed to go forward with his personal actions, and I would ask for the remainder of my time for rebuttal.
Thank you, counsel. We will now hear from the appellees.
Morning, Your Honor. May it please the
Morning.
court. My name is John Belcher. I represent Ace Technologies, LLC. There are two appellees in this case. Mr. Haynes represents Mr. Tramel, who's the second appellee, and we have agreed to split our time equally, if it pleases the court.
Not sure. Oh, I guess we can. We normally can't split like minutes, but apparently Mr. Hebner has found a way to do that, and I'm good with it if he can make it work. So you may proceed.
Thank you, Your Honor. Your Honor, we respectfully request that the trial court be affirmed. The trial court dismissed this case at summary judgment, and we ask that that ruling be affirmed in all respects. There are
Let me pose a question to you before we start. It does not seem like to me that there are any factual disputes. Would that be correct?
I agree with that, Your Honor. There are no undisputed material facts whatsoever with respect to the claims against Ace or any of the appellees for that matter.
Okay, proceed.
There are two broad issues with respect to Ace. One is that all claims at issue here belong to Action Security, which is a corporation. There was no assignment to Mr. Hight, and Mr. Hight is, it's undisputed, the sole plaintiff in this case. So therefore, he did not have the authority to bring this case. And number two, all of the claims would be barred by the statute of limitations. And that's what the trial court concluded, and we would ask that they be affirmed. The facts relating to both issues are undisputed. The procedural history, as Mr. Grimmett referred to, is that there was a prior lawsuit brought in 2014 by Action Security, by the corporation. That lawsuit was non-suited in 2016. In 2017, Mr. Hight filed this present suit, and Action is not a party to the present suit, and that is undisputed. So the issue becomes whether there was a valid assignment or not. The second issue is whether the statute of limitations has run or not. A couple of brief facts, I think, put both of those into perspective. In the first suit, when Action was a party, Mr. Hight appeared and sat for a deposition, and he testified in the course of that deposition that he was the president, director, and owner of Action. He testified that had always been the case. He testified he was there as their corporate representative. And only at the end of that deposition, when we were going through a list of potential witnesses and he was asked about Eric Roberts, did he reverse all of that testimony and reveal that during the course of the first lawsuit, he had actually sold Action to Eric Roberts. He revealed that Mr. Roberts might not even know he was there that day. Mr. Roberts might not even know the lawsuit was still going on. He was unclear who would get the money if he prevailed, and he was unclear who would pay the counterclaim judgment if he lost. It was only after that deposition that Mr. Hight and Mr. Roberts executed this, what they've called a settlement agreement. In that agreement, they were both, or at least Mr. Hight was represented by counsel. And that settlement agreement is what is at issue in this case. And it is what the plaintiff claims gives him the authority to file this new lawsuit. And on the four corners of the agreement, it just simply doesn't do that. Action Chiropractic says an assignment has to be clear. It has to describe the subject matter of the assignment. It has to be unequivocal. The assignment has to be manifest. And the trial court correctly concluded that the four corners of this agreement don't assign the claims from Action to Mr. Hight. For one thing, Action is not a party to the agreement. And the trial court correctly concluded that Action is the only one that can assign its claims. And since it's not a party, there was no assignment. The trial court also concluded that the four corners just don't do what Mr. Hight says they do. Even if we get past the fact that Action is not a party, the four corners of the agreement don't assign particular claims or choses in action or rights or remedies. All that agreement does is solve the problem or attempt to solve the problem that Mr. Hight realized he was in at that first deposition, which is who would collect the judgment from that original lawsuit and who would pay any counterclaim. And when we look at the language of that settlement agreement, it's by and between Clarence, Hight, and Eric Roberts. It refers to that lawsuit filed in Davidson County Chancery Court in 2014. It refers to all judgments which may arise therefrom. It refers to Mr. Hight paying all costs or judgments that might be entered against Action. And Mr. Hight says in his various briefs that they entered that in order to resolve the issue of whether he had authority to act as Action's corporate representative. It refers again in paragraph 6 to that legal action. Mr. Hight was represented by counsel, and at the end of the agreement, Mr. Hight signs it and Mr. Roberts signs it. The trial court looked at that on its four corners and said that is not a clear and unequivocal assignment of a right to bring some future action in some future court by a different party. That is just an attempt to solve this issue in the old case of who would receive any judgment and who would pay any fees or any counter judgment. The second thing I would draw the court's attention to is the undisputed factual timeline. And again, there's absolutely no dispute that Mr. Hight was on notice of these claims and that Action was on notice of these claims back in 2012. And in 2013, he was actually hiring a computer expert to review his computers because he suspected that Mr. Tramel had copied some documents. And so that notice is when the clock started running on his statute of limitations. And of course, he did not file this case until 2017. So I think it's undisputed that the claims would be barred by the statute of limitations and are barred by the statute of limitations, unless Mr. Hight can shoehorn himself in and argue that he gets to avail himself of the savings statute. And the trial court correctly confirmed or correctly ruled that the first case was brought by Action Security, a corporation. Mr. Hight was not a party, and that case was dismissed. Action had a year to refile, but Action did not refile. Mr. Hight refiled. Actually, he didn't refile. He filed a new case. Mr. Hight filed a new case, and Action is not a party to that new case. The case law on the savings statute says there needs to be an identity of parties. It needs to be the same party. The savings statute does not allow anybody to go out and shoehorn themselves in to file a new claim, and that's what Mr. Hight has done. And for those reasons, we believe the trial court correctly granted summary judgment to both defendants. And again, with respect to Ace, there never was any contract or non-compete or anything that put Ace in privity with Mr. Hight or Action. And we believe the trial court should be affirmed in all respects. And thank you very much.
Thank you, counsel. We'll hear from the other appellate counsel. You're muted, I think.
Good morning.
Good morning.
And may it please the court. My name is William James III, also known as Paz Haynes. I'm representing appellee Donald Ryan Tramel in this matter. And we concur with our co-appellee that the Chancery Court correctly awarded summary judgment to the appellees in this matter. The appellant lacked privity of contract or with Mr. Tramel or standing with regard to that agreement between the old company, his old company, Action Security, and Mr. Tramel, nor did the appellant have standing to bring claims under the Tennessee Uniform Trade Secrets Act because those trade secrets remained with Action and were not retained by the appellant upon the sale of his shares. And also, nor did he have the standing to bring claims for unfair competition for passing off ACE as Action Security. Those claims, again, both stayed with Action. The appellant lacked a valid assignment of those claims, but even with a valid assignment of the trade secrets and unfair competition claims, Mr. Hight's purportedly assigned claims would have been barred by the statute of limitations, and he cannot avail himself of the saving statute or any other tolling doctrine cited on appeal. Now, Mr. Belcher and Mr. Grimmett correctly referred to the history of the prior litigation. I was not counsel of record during that litigation, but with regard to the settlement agreement, which is on page 45 of the record, again, Action was not a party to that agreement. It was only an agreement between the seller of the shares, Mr. Hight, and the buyer of the shares, Mr. Roberts. Paragraph 4 specifically states that all parties hereto agree that any and all judgments which may be obtained as a result of that lawsuit, meaning the prior litigation, shall be owed to Mr. Hight personally and shall be paid immediately to Mr. Hight if paid to Action Security Systems, Action Security Alarms, Inc. Paragraph 5 stated, the parties hereto further agree that any costs encumbered or any judgments obtained against Action Security Systems, Inc. as a result of the above referenced lawsuit would be paid by Hight. So that assignment only dealt with proceeds or judgments obtained by Action with regard to the prior litigation, and essentially indemnified Action in the event any judgments or costs were assessed against Action in that litigation. Now, it was only relying on that settlement agreement that Mr. Hight filed this lawsuit individually and on behalf of Action, claiming he had standing by virtue of the assignment of all proceeds and interest. The appellees filed motions to dismiss the new lawsuit. As a result, the court entered an order of partial dismissal, but the order conceded that the only plaintiff that is a party to the complaint is Clarence Hight. And at present, Action Security Systems is not a party to the case. If a corporation sues a party and the principal sells the shares of the company, then the seller no longer has standing to prosecute the case for the company. When Action was sold, the new owner did nothing to move the case forward. So essentially, after partial dismissal, Mr. Hight had 4 claims left in the lawsuit: the claim for breach of contract, the trade secrets claim, the unfair competition claim, and the individual claims. The first 3 claims belong to Action, not Mr. Hight. He's not a shareholder or authorized representative of Action, and the law is clear that a corporation is a distinct legal entity. Action is a company in good standing, or at least was at the time summary judgment was entered, and had every right to refile the lawsuit, which it chose not to do. So it's clear to the Chancery Court that based on the undisputed facts, the only way the appellant could bring these claims on his own behalf if he were assigned the claims of the settlement agreement. And the Chancery Court explained clearly why Mr. Hight didn't have a valid assignment. First, the court found that Action could not assign claims to Hight in an agreement it wasn't a party to. Second, Mr. Hight was only assigned the judgments arising from the lawsuit. As the Action chiropractic case states, a valid assignment must contain clear evidence of the intent to transfer rights and describe the subject matter of the assignment. And the settlement agreement was clear in the four corners. It assigned the judgments and proceeds, not the claims. Now, as to the settlement agreement specifically, it only assigned the proceeds of the judgments. It did not give Mr. Hight the right to refile claims in a new lawsuit for his own benefit. It made no sense for the Chancery Court for Action to be dismissed from the lawsuit while Hight brought the claims on Action's behalf. Even if Mr. Hight maintained a valid assignment of claims, as the Supreme Court noted in the Red Wing case, the statute of limitations accrues upon discovery based upon actual or constructive knowledge of the injury. And as the Supreme Court also noted in the Wyatt v. Abess case, a plaintiff is not allowed to wait until all the injurious effects are known to file suit. The 3-year statute of limitations under the Trade Secrets Act and for unfair competition, and for that matter, Mr. Hight's individual claims, began to accrue at latest in March of 2013 and expired in March of 2016. Mr. Hight filed suit 11 months after that, in February of 2017. The 3-year statute of limitations, which Mr. Hight concedes, 28.3105A, for injuries to property expired when the trade secret statute did in March of 2016. And as Mr. Belcher pointed out, Mr. Hight cannot avail himself of the savings statute, nor can he avail himself of the continuing violations doctrine, which is a Title VII concept of tolling. So with that, I've exceeded my time, and I thank you very much.
Thank you very much. We appreciate your argument. We'll now hear a rebuttal from the appellant.
Thank you, Judge. Specifically, I heard that Mr. Haynes kept repeating the word standing. And that is a question in this case, whether Mr. Hight has standing. But that's also a repetition of a word that was in the settlement agreement. A word that specifically says, quote, Hight has standing in order to pursue that legal action on behalf of Action Security Systems. There is nothing more unequivocal than that language. The parties wanted Mr. Hight to have standing to pursue this action on behalf of Action Security. That is the title of the new lawsuit, Mr. Hight individually and Mr. Hight on behalf of Action Security. That language is taken specifically from the settlement agreement. Ultimately, the question is, what was the intent of the parties? Here we have two defendants to a lawsuit who are not parties to that contract. Two defendants who have everything to gain by Mr. Hight not receiving that assignment. And yet they are interpreting this contract, and yet they're not parties. Mr. Hight was a party. He interprets the contract to say that he has standing. One other thing I would like to touch on as far as rebuttal goes is the voluntary non-suit. One of the cases that was referred to is the Turner case. And I believe it was Mr. Tramel's argument that the Turner case can be differentiated from this case. In Turner, it was an employee who filed suit against a door manufacturer approximately 2 years after the original non-suit. In that particular case, a new defendant was added to the case. In this particular case, we're not adding a new defendant. We're not really adding any defendant. We're not adding any kind of party. We're simply saying that Mr. Hight is filing on behalf of Action Security. Mr. Hight has that authority. He should be allowed to do it. As far as this case, this is a de novo appeal, which means that your honors have the ability to look at this with no presumption of fact, no presumption of truth for the court's findings below. Given that, we would ask that summary judgment should be dismissed and that Mr. Hight should be allowed his day in court. Thank you very much.
Okay, thank you, counsel. We certainly appreciate you participating in this process. Hope you have found it useful and that it does what it needs to do. Again, we appreciate Mr. Hibner and all his work putting this together, as well as the AOC staff, or the technology staff rather. And we will endeavor to get you an opinion as quickly as possible. We appreciate your arguments. We appreciate your fine legal ability that was on exhibit here, and we will be in recess until the call of the next case. Mr. Hibner.
This honorable court is now in recess until 10 a.m.